Bismillahirrahmanirrahim. Mr. President, distinguished members of the court, my task today is to conclude Somalia's presentations at these hearings. As you heard, Mr. President, Kenya continues to insist that the 2009 MOU constitutes an agreed method, and an exclusive one at that, for the settlement of the maritime boundary dispute between our countries. Our Council has explained the reasons why that argument is unsustainable as a matter of fact and law. From Somalia's perspective, there is an even larger level at which the argument simply makes no sense. On Wednesday, the Honorable Agent of Kenya said that the dispute arises in a delicate political context, and that Somalia has only recently begun to emerge from a long period of instability caused by civil war, humanitarian disaster, and widespread terrorism. That may be true, but in our view, it only underscores why the MOU could not possibly bear the weight that Kenya seeks to place on it. When the MOU was signed in 2009, it was an even more delicate moment in Somalia's rebirth. At the precarious juncture, the transitional federal government had only recently assumed office. Somalia could have had no interest in binding itself to reach a negotiated settlement, and forever preclude itself from seeking judicial recourse. Nor could it have had an interest in committing to reach a negotiated settlement only after the CLCS issued its recommendations many, many years hence. Why would Somalia have an interest in entrenching uncertainty and instability in relation to its borders for long years, perhaps decades to come? Having relied heavily on the assistance of the international community, Somalia could have had no reason to prevent itself from seeking this court's assistance in resolving an issue of such great national importance. On the contrary, Somalia had every reason for keeping all of its options open, particularly those that would result in a fair, independent, and expeditious appraisal of the merits of its maritime claims. Mr. President, members of the court, in its arguments before you, Kenya also continues to insist that we somehow rush to the court in a circumstance where there was no urgency. In that connection, it is quick to tell you that it voluntarily suspended its unilateral activities in the disputed area. Somalia, it says, should have no fears. Well, this is news to Somalia. We had never previously been informed that that was the case. In considering Kenya's change in behavior, I would respectfully remind the court that less than a month before Kenya filed its preliminary objection in October 2015, it was soliciting tenders for seismic surveys to be carried out in the disputed area with a view to issuing licenses in 2017. In particular, in September 2015, the National Oil Corporation of Kenya published an expression of interest for provision of a 3D multi-client broadband seismic offshore survey in the shallow waters of the Lamu offshore basin. The tender document officially announced that the company and Kenya's Ministry of Energy and Petroleum were preparing for an open licensing round tentatively scheduled for the year 2017, and that a formal announcement on the date from the Ministry of Energy and Petroleum is expected soon. The document included a map which shows the shallow offshore area to be surveyed, extending all the way up to the parallel boundary that is claimed by Kenya, contrary to international law. And just the year before, in 2014, before we filed our application, 2D seismic surveys authorized by Kenya were carried out in a number of blocks that encompass the disputed area. And one of its licensees even conducted a sea core drilling operations in one of the disputed blocks. It was exactly this pattern of behavior that was of such concern to Somalia since 2014 and ever since, and has heightened our sense of urgency to secure a fair and objective determination of what is ours. Mr. President, members of the court, Kenya also returned again to its contention that it has exercised undisputed sovereignty in the area in dispute since 1979. This is an issue that is of no relevance to the jurisdictional issue before you. It goes to the merits, but it helps explain why negotiations between both countries failed. Kenya was unwilling to budge from its long-standing position that the boundary had to follow the parallel of latitude. Only that boundary would justify its activities in the maritime areas it's regarded as most promising for economic development. This is a position that no Somali government could ever accept. Ironically, Kenya may have unwittingly contradicted its own argument on Wednesday afternoon. In his opening remarks, Professor Akhavan said that the Kenyan Navy has patrolled these waters for several years now as part of the African Union mission in Somalia, endorsed by the United Nations Security Council. So accepting Kenya's word as true, which Somalia denies, as no AMISOM forces had in the past or is currently patrolling the Somali seas, it appears that Kenya now claims to have patrolled the waters in dispute not in the exercise of its own sovereignty, but as a member of a broader African Union mission in Somalia. In any event, it is exactly this situation of confusion and conflicting claims that makes the early resolution of maritime boundary dispute between our two countries necessary and urgent. As I said on Tuesday, we place great value on our deep and close ties with Kenya. We also recognize the significant contributions that they and others have made to the rebuilding effort of Somalia. That said, Kenya's security concerns are shared by Somalia and indeed the entire world. Somali soldiers too are paying the ultimate price defending their own country, sometimes doing it with their own bare hands. We have all made sacrifices, and we will continue to do so until Somalia and the whole region are secure. Kenya's sacrifices, like those of other countries, including Uganda, Djibouti, Burundi, and many others, do not constitute a reason to deny Somalia the rights to which international law entitles it. Kenya cannot, as it seems to suggest, expect compensation in the form of maritime areas that would otherwise appertain to Somalia. Kenya's political arguments have no bearing on the legal task before this court. Mr. President, members of the court, our maritime boundary dispute with our Kenyan brothers and sisters is just one element of the overall relationship with our Kenyan friends. But it is real, it is also intractable, which is why we had to come to this court. Mr. Reichler reviewed the history of negotiations on Tuesday and again this morning. After successive rounds of talks, we were at loggerheads. Further negotiations showed every sign of being pointless. We saw no reasonable prospect of success. It was as if we were speaking different languages. It was even worse than a conversation between civil law and common law lawyers. We couldn't even get past basic questions of methodology. They wanted a parallel of latitude and refused to budge. We insisted on equidistance. In accordance with the court's jurisprudence, they rejected it out of hand. Nevertheless, Somalia agreed to one final round of talks at Kenya's insistence. Both parties understood that this was to be a final attempt to reach an amicable solution. Kenya has not disputed this. To our great surprise, they didn't show up, nor did they tell us why they didn't show up. They have not disputed this either. Now they claim that they had security concerns. Yet, they failed to mention to this court that we had offered to hold the last round of talks in Djibouti if they had so desired. They never responded to that offer either. In a circumstance where we perceive an acute threat to our rights, where Kenya was unilaterally exercising control over our maritime areas and resources, and where the court could be stripped of its jurisdiction literally any day by a modification of Kenya's optional clause declaration, it was not only reasonable for Somalia to come before this court, it was fully justified in doing so. In your wise hands, this thorn in the side of our otherwise strong relations can be removed in good time. We can move forward together in an era of greater peace and stability, with both sides securing the knowledge of its rights and able to finally utilize its resources for the benefits of its own people. Mr. President, distinguished members of the court, I will end as I began on Tuesday, with an expression of thanks. I wish to echo the remarks of the Honorable Agent of Kenya on Wednesday when he thanked the able registrar and the personnel of the registry for their diligent assistance that has made these hearings run so smoothly. We also wish to thank the court interpreters for their typically exceptional work, as well as the other members of the court's staff. Finally, Mr. President, we wish to thank you and all the members of the court for your very courteous attention throughout these hearings. Somalia confidently entrusts the matter of Kenya's preliminary objections to your wise judgment. I will now read Somalia's submissions. On the basis of its written statement on 5 February 2016 and its oral pleadings, Somalia respectfully requests the court to reject the preliminary objection raised by the Republic of Kenya and to find that it has jurisdiction to entertain the application filed by the Federal Republic of Somalia. Mr. President, distinguished members of the court, thank you for your time and good morning.